Good morning. Good morning. Mr. Rice.
Good morning. May it please the Court, my name is Daniel Rice for the appellant. By the defendant's argument, a small employer in Massachusetts could have its manager call an employee into his office, call him the most offensive racial slur you can imagine, fire him, tell him that he was firing him for that reason, ridicule him as he walked out the door, and that employee, in the aftermath of this, would have no remedy available to him under Massachusetts law.
Well, he may have a remedy under the breach of covenant of good faith and fair dealing, might he not?
Depending on whether or not you could divine language out of an employee handbook or some other source. But what the law should address, and what it does address, Justice Marshall, is the racial motivation of that action.
Well, what you're saying certainly presents a problem, and isn't that something that should be addressed to the legislature?
The legislature has addressed it, and as the client in this case theorized in her complaint, under GLC 93 sections 102 and 103, discriminatory acts of that nature are proscribed in employment and in other contexts.
Go ahead. Excuse me, finish.
The law broadly proscribes discriminatory acts, and
what
it
about
was intended to do so.
What about the situation where someone has a two-family home, they're a live-in landlord, and they determine not to lease the second family part to someone based on their religion, ethnicity, race, sex, whatever? I take it your argument was, oh, that would be a violation of the civil rights statute as well.
The language in Section 102 seems to cover that specifically.
Even though the legislature has specifically exempted those homes from this kind of action.
Again, and that is not the claim as Thurdin is making in this case.
I understand that, but your argument that this statute was intended to address discrimination of all of these sorts wherever they might occur, even in contexts where the legislature has specifically exempted small businesses, family owners of two-family homes, that all of that's been wiped off the books by this statute.
Your Honor, again, Justice, this is an employment claim. In that context, though, we would take the position that the civil rights laws should be looked at harmoniously. Now, there's a specific proscription in this law about property transactions, and that could be implied.
You do seem to have an awful lot of legislative history going for you, do you not?
Yes. And
in fact, it's one of the few cases I've seen where there's a clear paper trail here that they intended to do away with that Patterson decision and put the state of affairs back to what existed in the Runyon case. Am I right?
You're right. And I brought one document with me up to the podium here. The fact sheet supporting the legislation states specifically that the bill was intended to restore the right of women and minorities to sue for money damages in cases of on-the-job discrimination.
And that fact sheet was prepared by who?
That was prepared by Senator Oliver, the House Majority Leader.
Well, the Civil Liberties Union brief lays it out in great detail. Not only that, but Governor Dukakis's message, Senator Oliver's, what you just described from him,
and it was
the
very
way
clear.
It worked its way through the committee. I don't know.
Including the Attorney General of this state, who sought assistance in making sure that the citizens of the state and employees specifically would not be deprived of their protections against discrimination by the rollback of federal law.
So the small business exception is now gone. All of the legislative debate that went around the complications in applying these discrimination claims to businesses of 2, 3, 4, 5 people all of that deliberation, and trust me, that was a great deal of where we draw the line, all of that is gone.
That debate would have taken place in the mid-1940s. This bill and this law was codified in 1989,
Yeah, well,
40 years later.
The employment
and of course, the legislature was entitled to and did step in and fill in a gap.
Well, they didn't mention 151B in this statute, did they?
But there would be no reason to.
In 103, it's mentioned, which is part of this legislation. Could I ask you this? You know and I can't find it now, but one of these briefs talks about the statute that provides for specific, that employers with more than 6 employees have to give up to 8 weeks of maternity leave unpaid to their workers, but it's specific about employers with 6 or more employees. Do you know when that was passed?
I do not. I would be venturing a guess.
Well, I guess my question is, how do you reconcile, I mean, that's a pretty specific statute. I mean, it goes along with 151B's limitation as well. And what do you do about that specific limitation with respect to Section 102? I mean, because this is a claim about, obviously, about pregnancy.
But the claim wasn't for leave.
No, I understand that. But
that's the basic factual distinction. The policy behind the maternity leave statute, and again, I'm speculating, though I think it's an educated guess, is that smaller employers might not be subjected to it because of the size of the workforce. In this case, we've stated a pregnancy claim that is equivalent to a gender discrimination claim, which is what the case law on this is. And it's very different. It's a much more basic act of discrimination, something that the legislature has to get directly at. Maternity leave is a different issue.
because it's a you would say, I think, because it's giving something. It's not prohibiting or discriminating. It's actually giving a benefit.
Yes.
So you can limit to whom you give the benefit.
Correct.
I'm sorry, you said that 151B is mentioned not in 102, it's mentioned in 103?
I think so.
And what does it say? How is it referenced?
Quickly refer to the statute, but I believe it's definitional. Yes, I'm correct. It's at age and handicap as defined in Chapter 151B. It's an incorporation by reference.
Okay, so that's the only reference here to 151B, that any person within the Commonwealth, regardless of handicap or age, as defined in Chapter 151B.
And I would take, it's fair to take from that the definition of employer, of course, is not incorporated by reference. Rather, the Mass Equal Rights Act is drafted broadly to cover the transaction, the employment, the transactions that might take place in the employment relationship and others. And those actions, as far as they're discriminatorily motivated on the basis of the protected categories listed therein, are absolutely prescribed.
Nothing mentioned employment, of course.
Well, it's
Contracts.
Contracts. And it's
but nothing
a
mentioned
bedrock
employment.
principle that the employment contract, unless stated otherwise, is a contract terminable at will. And this Court has held many times and affirmed many times that it is a contractual relationship.
I take it that with respect to this issue of whether, assuming 102 applies, does it only apply to pre-employment or in-employment discrimination? You would again point to the legislative history as being specifically intended to go back to Runyon.
I would point to that, but as well, I'd point to the precedents of this Court, which define the employment relationship as an ongoing contractual relationship, not one that's contractual only at the formation stage. You have many cases, including the Geyser case that's cited in the appellant's brief and also the brief of the amici, that establishes that the employment relationship is a succession of ongoing contracts. To say that it's otherwise, to say that once you're hired, you no longer have any enforceable rights, and actually enforcement is the word that's used in 102, is to mistakenly construe the nature of the employment relationship.
As a matter of fact, 151B, Section 9, first paragraph, says nothing contained in this chapter shall be deemed to repeal any provision or any other law relating to discrimination. So it's highly arguable that that provision integrates, if that's the correct word, or references the statute you're suing under.
Importantly, the amendment to that statute and the clarification of the nature of the administrative remedy was amended in 2002 after the Mass Equal Rights Amendment, Mass Equal Rights Law was passed. And also, it's important to point out that that's consistent with a case law. There are cases which you've decided, including Charland and a few others, which indicate that an employee has to exhaust remedies under 151B. But thereafter, after it's removed to Superior Court, the employee is free to pursue any other civil rights or employment right law that's available to him, including the Massachusetts Equal Pay Act. That's the Jancy decision that you've made. And there are others.
If Congress had added to 42 U.S. Code Section 1981 the words performance, modification, and termination of contract to the original words make and enforce in response to Peterson, why wouldn't our legislature have done the same thing?
The legislature probably believed it had taken care of it. Now, there's a temporal sequence to that. The concern about what would happen with the Supreme Court decision was raised because it was announced that the court was going to consider rolling back Runyon. And that's when
it was announced that the court had granted a petition for cert, right? Not that it would go, but that it was going to reconsider Runyon. It didn't say what it was going to do with it.
No, it did say it was going to reconsider Runyon.
Well,
I said reconsider Runyon. It didn't say what it was going to do with it.
I think the important point of that, though, is that the legislature, or in the Massachusetts Attorney General, was concerned that the decision that was coming was going to roll back rights. And what you have is very clear legislative history meant to counteract that ahead of time. And the introduction of the legislation took place before that decision was actually made. The bill was engrossed before the decision was made.
You know, it's interesting. One of the briefs mentions that because of the way 102 works, everything from statute of limitations to damages, the way 102 works, in effect, if we interpret this statute to specifically apply to employment and employers who have less than 6 employees, it is actually more onerous on the smallest of employees that the statute 151B was intended to protect than 151B is with respect to all other employers.
I respectfully disagree with that. 151B and the administrative authority or police powers that the MCAD has over employers with 6 or more is much more onerous. And in fact, as a practical matter and as a practitioner, I'd be familiar with this, it's much more likely for these cases to be filed against larger employers and for larger employers to have to deal with them. Now, employees have the right to keep their cases up at the MCAD.
Well, you say the equal rights case would be filed against the larger employers for employment discrimination? That's not possible, is it?
Well, after exhausting administrative remedies and removing it to court, it is. And
I'm sorry.
There's case law on that point. What I'm arguing about.
So you're saying 151B, if it applies, isn't the exclusive remedy. You can sue 151B.
No, I think that's well settled. It's never the exclusive remedy. It's the exclusive administrative remedy if
it's like a
it
gatekeeper.
applies. If you work for an employer with 6 or more employees and you allege discrimination, you have to go to the MCAD.
Correct.
Once you remove it, though, you can certainly sue under 93-102, 149, 105, or any other law.
You can sue under 102 for the same employment discrimination that you could have pursued under 151B.
And it's an independent right. And by the way, that is consistent with federal law. under federal law, you can sue under Title VII, and you can also sue under 1981. And that's actually a principle that's cited in the Patterson case itself. But I would like to get back to the issue about the MCAD. The MCAD has plenary authority. It has police powers. It can order employers to comply with
But
matters.
what would be the purpose then of exempting employers with fewer than 6 employees from the whole MCAD process?
Well, I think that purpose existed in the 1940s, and as societies changed, and as the recognition of the problems of discrimination have become more in the public knowledge, our legislature took steps to fill that gap.
But the employee with a claim against an employer with fewer than 6 employees would not have to go to the MCAD. You agree, or you don't
I
agree?
do agree, because
So I'm saying, what's the purpose of is there any purpose, any reason why the employer with fewer than 6 employees should not go before the MCAD?
well, I think I'm not sure I understand your question, but I believe I'm answering it. An employee of an employer with 6 or more does have to go in front of the MCAD.
Right.
After, and that, by the way, is a matter of filing a charge and asking the MCAD for a right to sue if you want to go to Superior Court. Once that's done, you have everything available to you, any statute available
Right,
to
but
you.
you can't slough off the MCAD. I mean, they have a purpose and a function, and I assume that they're performing it correctly. So why shouldn't
employee
the
has-
others have to go, the smaller employees, say?
Because those employers aren't required to. The MCAD
No,
doesn't
I
have
know they're
jurisdiction
not.
over 6 or less, okay?
I
And that's
know.
jurisdictional, but their remedy is not exclusive, or the proscription's not exclusive.
What remedy did an employee of an employer having fewer than 6 have in 1950, before the Equal Rights Amendment was passed?
Well, it depends. If it was a race-based act of discrimination, I would argue that they would have a remedy under Section 1981 of the federal law.
Under
But
Massachusetts
under
law.
Massachusetts law, I don't believe they would have a remedy. If
They might have a constitutional remedy.
they might, under the Declaration of Rights, and I think that was well cited in the brief of the amici, that these laws are derivative at that level, at a basic level of rights that are conferred by the Declaration of Rights.
Thank you, Mr. Leiss.
Thank you.
Mr. Berman?
Good morning. May it please the Court. Joseph Berman on behalf of the appellee. The issue in this case is whether the Mass Equal Rights Act, Chapter 93, Section 102, silently repealed the definition of employer in Chapter 151B, Section 1, Sub 5.
Well, I
which
don't think
accepts
it's
the
repealed.
definition.
The question is whether it complements that definition to extend the statute to employers with less than 6 employees.
But in essence, Your Honor, what it would be doing would be repealing that section, because what it's doing is under the plaintiff's theory, in response to the last question, I think, prior to the amendment of the Equal Rights Act, there wouldn't have been a remedy against an employer
What's
with
only
fewer than 6.
applicable to is, as I remember the terms, it has a limitation to the making and enforcement of contracts.
But didn't you always have a right in Massachusetts in a court of equity to prevent a violation of a constitutional right?
I think there are certainly constitutional remedies. There were federal law, both statutory and constitutional remedies. The plaintiff's argument here is purely that the Mass Equal Rights Act added a specific statutory remedy in 1989.
Mr. Berman, what do we make of the fact, do you agree that the statute appears to have been in reaction to the Supreme Court granting cert to reconsider Lanyon?
You know, there's a lot of information about what was going on, either consciously or subconsciously, in the minds of the legislature and the governor in 1989. And I think it's important, and in response to some of Justice Greeny's questions to my brother earlier, to clarify exactly the chronology here, because I think it's important. In 1988, the Supreme Court granted cert in Patterson, and whether they explicitly or implicitly said so, everybody was concerned that they were going to revisit Runyon, and that
Well, they
could
said
open
so
up.
explicitly. They
Yeah,
said so
it
explicitly.
could be a big can of worms opened up. in anticipation of that, and so, then you have another, 9 months to a year between when they grant cert in Patterson and when they actually issue the decision. The legislature, the general court, took up a possible measure in anticipation of what might happen. And that's where you get the statements from the BBA, from the Bar Association, the statements from Senator Olver, the statements from Governor Dukakis about what they were trying or intending to do. But at the end of the day, first of all, Patterson did not go so far as the sort of the worst-case scenarios feared as far as what they were going to do with Runyon.
Well, it did, because it excludes this plaintiff from any relief under the...
It would, but it didn't say, as some feared, that there would be no remedy under Section 1981 for any private discrimination.
I understand that, but
that's irrelevant.
Yeah.
The question is...
what did this legislature mean?
Exactly, and I'm looking at the Act Relative to Equal Rights, which is part of one of the amicus briefs, and it says, this legislation will ensure that discrimination does not occur based on sex, race, color, creed, or national origin. Right. Later that was amended to handicapped and so forth. What can be clearer than that?
But, Your Honor, what they didn't... Remember, 1981 is a racial discrimination statute under the federal law. So there was a lot that Mira was doing that 1981 doesn't do. But I think the most...
Go ahead.
If I may just make this point. I think the most important point about all the legislative history and the chronology here is that at the end of the day, the legislature did not change the definition under the Equal Rights Act. It kept it as make and enforce contracts. Even after Patterson, and even after Congress 2 years later amended Section 1981 of the Federal Code to use phrases like make, enforce, modify, terminate, which was a direct reaction to the Patterson case. And our legislature, the legislature here, didn't do that.
But this is the enforcement of a contract, is it not? The woman got hired. She had a contract to be hired. They say, accepting her allegations is true, we're firing you because of your pregnancy. It's enforcement of a contract.
Well, except that Patterson would, if we were in the federal court, and if we were in the pre-amendment to 1981, Patterson would say that enforcement, that doesn't include enforcement. So if the legislature wanted to go as far as the plaintiff suggests in this case, then the legislature would have either immediately after Patterson or after Congress.
They did.
I appreciate that it's not precisely what may form the best kind of legislative history. But if you've got a letter on July 18th from Senator Olver, and you've got a press release accompanied by a letter from Governor Dukakis and signing this saying, we're putting this back to Runyon, I mean, I don't know what else it could mean.
Because there are other things that they were doing that they could have been doing, including expanding it beyond racial discrimination. Giving more remedies as far as whether a plaintiff could sue for compensatory or punitive damages. There were other things going on besides really two issues here. One, whether the make and enforce contracts extends to post-hiring decisions.
There was no question that Runyon was dealing with race, correct?
Yes. Yeah, and in the employment, in the educational arena, not specifically the employment arena. So I guess, Justice Botsford, what I would argue is...
I'm sorry, just say that again.
My memory of Runyon,
this was
if I
a
recall
former
correctly,
employee claiming that she was racially harassed because her employer failed to promote her and in fact discharged her because of her race. I don't think it's it may have been in an educational setting, but it is an employment case.
in Patterson.
Yes.
Yes, but Runyon was, if I recall correctly, and I may get this wrong, was in the educational
I'm sorry.
arena.
I thought you were talking about Patterson.
Now I forgot the question. I was going to go back to
I just thought that it seems to me that to say that, well, the legislature must have meant what Patterson meant because they didn't change the language more after Patterson was decided, and I guess I have some trouble with that argument, but that seems to be what you're saying.
Well, I think that's the argument as to why the Mass Equal Rights Act would be limited to decisions, sort of under a Patterson type of definition of make and enforce contracts. And again, the legislature had ample opportunity. They've had ample opportunity all the way through, either after Patterson or after Congress went ahead and said, okay, we need to clarify the definition in Section 1981.
Well, they didn't have to clarify it. They had to reverse the United States Supreme Court decision.
Right.
They didn't clarify. They reversed.
I mean,
what
if they thought they were doing it, ab initio? Why would they have to clarify it?
Well, whatever, they amended it. You can call it clarify, reverse. They made very clear, as a matter of legislative intent and plain language of the statute, that Section 1981 extended beyond the period of a hiring decision.
Yeah.
Our court didn't, our legislature didn't do that.
One troubling thing, and it works in your favor, at least it seems to, maybe you could comment on it, as it was referred to by Judge Cordy, and that is, if we go in the plaintiff's direction, aren't we also knocking out, for example, that exemption for landlords in owner-occupied one- or two-family buildings, as I remember, where they're given fairly much carte blanche to discriminate?
Right.
That would go out the door, too, wouldn't it?
Exactly, and I think we come back to some, very well-accepted and non-controversial principles of statutory construction, which is specific, particularly here, where under the plaintiff's theory, you're really making a sea change in employment discrimination law.
Now, on the other hand, I suppose it could be confined by saying there, the 151B, as I recall it, has a specific provision, a specific exemption. Maybe it won't work because they also say only 6 or more employees here.
The way it works, Your Honor, is the employer 6 or more is in the definition of employer.
Right.
That landlord provision that you and Justice Cordy are talking about are actually within the body of the law. I think it's Section 4, sub 7.
Correct.
Which has a very lengthy specific exception. But again, if the legislature intended in passing the Equal Rights Act to make this sea change under generally accepted and I think non-controversial principles of statutory construction, it would have said so. It would have done something to the statute just as it did when it passed Chapter 214,
Now, there's another way
Section
you
1C.
could argue the reverse of what we're talking about, and that is you could say when they adopted 151B, well, this act came after 151B, did it not?
By 45 years.
But 151B has been consistently amended.
Right.
Consistently
Do
amended.
you know when the exemption for small landlords went in?
For small landlords. I don't
The one
know.
we're in.
I know that the definition of employer, I think, has been there since 1945.
No, but that's under a different statute.
Well, the landlord exemption is within 151B, but it's within Section 4, which is, as I was just saying,
It would be
not the
interesting if
definition.
it came after the adoption of the ERA. That could be a sign that, well, the ERA sort of changes things. We better protect the small landlords and amend 151B, but we don't have to worry about the other part of it because the ERA is going to kick in.
My memory, and I may be
look at
wrong on
dates.
this, is that the landlord exemption predates.
It's been there for a while.
Yeah, I think it's been there for a while, and I think that we're getting a little bit into the range of speculation to think about trying to divine what the legislature was doing by not amending something. But I think it's clear, and I think that this sexual harassment statute, Chapter 214, Section 1C, is actually a useful comparison by contrast, because there the legislature created, because there were concerns that there may not be any protection, statutory or otherwise, for victims of sexual harassment, the legislature passed Chapter 214, Section 1C, amended 151B at the same time, and made it very clear that victims of alleged sexual harassment had a right to sue an employer even where that employer had fewer than 6 employees. And if you look at the legislative history, this is all set off very clearly in the briefs. By contrast, you look at what happened when the ERA was passed in 1989, and nothing like that happened. And there is certainly no indication, going back to the comments of Senator Olver and Governor Dukakis, that they were intending to change the definition of employer in 151B. Presumably, under rules of statutory construction, if the legislature were going to make that radical a change, they would have indicated as such.
I know that we're engaging in speculation, but how could the governor make a public statement like that if it weren't true, without any subsequent outcry that this isn't the purpose behind the statute by other members of the legislature?
I guess I'm not. I don't follow
The governor made this public statement as to what had happened when Chapter 93, Section 102 was enacted, and saying what the purpose was. If that, in fact, was not the purpose, why wouldn't there have been a groundswell of opposing statements from the members of the legislature?
Well, I think the governor's statement was a matter of public policy and political discourse, and it was talking about protecting rights of victims of alleged discrimination. It didn't specifically, I don't think, address. That doesn't amount to legislative history. He doesn't say, I hereby decree that the intent of the legislature was to do specifically X, Y, and Z. And in fact, again, if you look at the statute, they didn't amend it. They didn't change it to do X, Y, and Z.
Please finish.
I'm done.
Mr. Berman, help me, and forgive me for not recollecting this. Title VII, does Title VII have a limitation on the size of employers as well?
I believe it's 15 employees.
I believe it is. And what I'm struggling with is which is where I started my questions. If we accept, as Justice Fina seems to indicate, that the purpose of the Mass Equal Rights Amendment was to deal with the petition for cert and what flowed from, or was anticipated to flow from, a reconsideration of Lanyon, all of that was under 1981.
Correct.
1981 is not limited to employers of a particular size.
That's correct, because it's a general discrimination statute.
Correct. And so I'm a little at a loss to understand why we are looking at 151B, because Title VII has the same limitations, and it seems to me that in essence what the legislature has done is enact a 1981, as it were, expanding it, if it wants to expand it, to cover not just race but some other entities. And so it would be a little unusual if one were bringing a 1981 action today for an employer to say, but a small employer, less than 15 employers, to say, you know, I don't have to respond because the exclusive remedy is Title VII, or is in fact that the law?
Right. And Your Honor, and that's exactly, I think, the issue that in Patterson, and that's why Congress amended Section 1981 to make clear that if you are an employee of a company with fewer than 15 employees, Section 1981 did give you some rights. The Mass Equal Rights Act doesn't have that.
No, but that goes back to Justice Botsford's point. In essence, what Congress was doing was going back to Lanyon. Massachusetts had already gone back to Lanyon.
Well, we didn't have a Runyon on the books at the time.
No, I understand that.
But what we did, we passed, the Equal Rights Act was a new statute. I mean, there wasn't anything to be amended. So the legislature could have done, I guess they could have done this with an amendment, presumably anything they wanted to do. They could have made that definition as broad as they wanted to. There were a lot of things going on in the Equal Rights Act that have nothing to do with employment discrimination. It talks about making, inheriting property and the right to sue and all these other things that also, it's not just limited to alleged racial discrimination. It has to do with gender, national origin, et cetera. So there were a lot of things going on there. What I think the legislative history and the plain language of the statute makes clear is what they weren't doing is changing the definition of employer in Chapter 151B and saying that particularly if you're not talking about a right after the initial hiring decision, after the making and enforcing of contracts, you're an employer with fewer than 6 employees cannot be sued under the Equal Rights Act. And just to pick up on Justice Cordy's point earlier, it would lead to an anomalous result. I mean, whatever you want to talk about as far as the procedures of the MCAD, in fact, a small company would face a longer statute of limitations, an easier burden of proof because it's totality of the circumstances under the Equal Rights Act. It is I think, it defies common sense to think that somehow the legislature was going to make it more difficult for small companies. They did it in the sexual harassment statute by very specifically amending 151B. They did not do this with respect to 151B and the Equal Rights Act. Thank you very much.
Thank you, Mr. Berman.